Chase Strangio here. Chase is a staff attorney at the ACLU who predominantly works with the LGBT and HIV projects, and we are thrilled to be in dialogue.
I am really happy to be here, and I really look up to Chase, and so this is a great opportunity to just have a conversation and us to start it, but really for it to be a dialogue. And every time I do a talk, somehow it gets titled something like the legal fight for trans rights, which is like everything I don't believe in, which is nobody's fault. It's just sort of like naturally how I am situated. And so I always want to, so to the extent I'm associated with a legal fight for trans people and rights, I do want to say that that's like entirely antithetical to my vision of my work. So perhaps that's like a good place to start, in part because I don't really believe in rights and I don't really believe in the law. But I am a lawyer, and so I do sort of play around with these concepts. And so whenever I talk about my work, I always try to situate, and it's different every time, but sort of the thing that I use to keep myself grounded, to remind myself that every intervention that I do as a lawyer is one that is of course compromised and constrained, but also one that really does perpetuate harms in one way or another, no matter how well-intentioned we are. It's just the nature of the system. And so the thing that I keep by my desk right now is this sentencing transcript that I will read to you a section of, just to just sort of be ever so clear about the anti-blackness of the legal system. And it's a federal court sentencing of a black man, a criminal defendant in a case by a federal judge in open court on the record of a democratically appointed judge, and who's actually like figures in some very bizarre way as some hero in marriage equality that you don't quite understand. But anyways, so she's in open court and she's talking to the defendant, and she says, looking at him, and then I'll explain more of why I think this is important. She says, "I've grappled for years, and particularly the last 4 years, with the fate of young men like you." And this is very disturbing. So just to flag, the hyper-masculinized, enamored of guns, violent, thuggish. Almost all of you had terrible upbringings as a result of the awful decisions made by your parents, starting with the decision, which really wasn't ever much of a decision in the first place, but more like an afterthought to have you at all, when they were incapable or unwilling to take care of you. The problems that lead to the kind of upbringing that you had are so deeply entrenched in our society and so poorly understood or addressed that I don't even begin to know how to make things better. But I can make things better for the people who were in those stories by putting you in jail, and I believe that is the right thing. And I really just, this is both so disturbing because it is an exceptional documentation of how our legal system operates, and the idea that we act surprised about the systems that we've put in place and relied upon since the founding of our country and before, and that and at the same time that we really do operate to maintain white supremacy to such an explicit and obvious degree, and through the operation of the violence of our criminal legal system, literally to the point of a white woman who's a federal judge telling a young black man that he never should have been born at all, and the only solution to his existence is to incarcerate him. And of course, this is the operation of the regime as a whole. And it's not like you can say, oh, well, that's the criminal system, and you operate in the civil system, and therefore civil rights work is somehow more just or separate from this, because it's all part of the same system, and the interventions in it operate to legitimize it as a whole. And so when I do the work that I do, I'm always complicit in things like that judge's remarks, and the truth of sort of how and the degree to which we lock people up in our prisons and jails and other sites of confinement. So I worried when I started to work at an organization like the ACLU that I would become really caught up with sort of the narrative of winning civil rights protections and the goals of objective metrics for success, that I would lose sight of the system as a whole, and really have tried to hold myself to account to the reminders that no matter what we're doing, no matter our intentions, when we are advocates in the legal system, we are complicit in these structures. And so for me, that means making visible the structures, making plain in all of my work the costs and harms that I distribute, as sort of, you know, in all that I do. And so, and one example of this is just sort of, I got a lot of praise for representing Chelsea Manning, and a lot of, we both, you know, Chelsea is really hailed as a hero, and to me she is in many ways, and I was given a lot of credit for being her lawyer. But when you do advocacy on prison conditions work, really what you're doing is sort of just rearranging the violence of the prison system. You know, you're getting, you know, you're sort of using the pathologizing narrative of the way that healthcare is distributed to trans people, and sort of saying the prison regime as a whole is fine on some implicit level as long as you're meeting your constitutional obligations to provide care. And these are important life-saving interventions. Like, I would rather have, you know, my clients live and get the health care that they need than die, for sure, and that's an important choice, an important reality. At the same time, I think it's not enough to just stop there and say, okay, well, what else is happening? What resources are we putting into the system? And then in Chelsea's case, there's this separate piece where the reality of Chelsea's life is she comes out of prison, you know, she's a white woman, she's coming out of prison with hundreds of thousands of dollars and tons more resources than most people come out of prison with. And so she's also sort of hailed as this hero and put into this separate camp of individuals that sort of obscures the nature of the way in which people are coming in and out of prison as a general matter. And then the other thing, of course, is that all of the work that we do to advocate on behalf of individuals who are incarcerated, on behalf of trans individuals who are incarcerated, to get access to healthcare, which is what I was representing Chelsea for, is work that relies on the pro se, the sort of unrepresented advocacy of mostly trans women of color over decades to establish the standards that we now rely on in not just our prison work, but in all our healthcare work on behalf of trans people. And their work goes almost entirely unacknowledged and entirely you know, unrecognized in the public discourse about, you know, the fight for trans people. And I caught myself at so many moments just being all caught up in the sort of attention of it all. It's like, oh, Chelsea Manning is such a hero, and this is so important, and the world is changing, and we can have these conversations. But you see how it's so easy to lose sight of how to expose the system at the same time that you're trying to gain individual wins. And also validate your individual client's experience. And so this is something that I try to hold myself accountable to and for by both reading always about sort of how the system is operating, because you know you can lose sight of it. You can just decide you want to win your case against Trump's military ban and think that that's the reform that you've been waiting for, and then also recognize that that especially in groups of lawyers, it feels always important not only to talk about the mistakes we've made, but also really the harms that we've brought onto others. And sometimes that's through entrenching problematic legal norms that other people can't meet. Sometimes it's through interventions that don't understand the systems that we're intervening in. And so you might call a prison on behalf of a client and say, my client's been subjected to violence or is struggling with X, Y, or Z problem, and the system responds by, let's say, shutting down the entire unit and subjecting people to some sort of lock-in procedure, or strip searching everyone and searching their cell. And then your client is much worse off because they're now being retaliated against because you've completely disrupted the operation of the institution because you don't understand it. And so having those conversations about the practical implications of our actions as actors in this system it feels really important. And so when we talk about, okay, well, what does my work look like? What is the landscape of legal rights advocacy on behalf of trans people? It would be really easy to be like, well, Title VII means that you can't discriminate based on sex in schools, and that's actually not true. It means in employment. And Title IX means you can't. This is why I don't give that talk. I actually listen. But it's and yes, there's all these things happening. But those are actually not the things that are impacting people's lives, nor are the sort of doctrinal changes in the law the things that are driving both, sort of truly driving our movement decisions, nor are they driving sort of the outcomes of people's lived experience. And so it can be very dangerous to sort of look at a set of legal norms and legal paradigms and legal movements and think that that somehow translates into the conditions under which people live, or the set of choices that are available to either a movement or a set of individuals who are acting either within or against the systems that we're working in. So I guess, to me, the most interesting thing to do is always just say, well, I don't really believe in the law. And someone told me that was very disturbing, that I said that on Sunday. And that, it's very disturbing that we live in this horrible environment that we live in. So I'm also disturbed. And yet I work within it anyways. So I guess that raises a lot of questions about, well, so why or how? And those are things I'm interested to talk about if others are as well. Because I don't know that I'm always making the right call, and I don't know that that I'm using the access and the privileges that I have to be disruptive, or am I just merely entrenching things but having more conversations about it? And so these are sort of the questions we have to ask ourselves. And so I'm really interested in having that conversation. And of course, I am happy to talk about sort of, a case like Chelsea's, or a case like Gavin Grimm's, which went up to the Supreme Court and back down, and or any number of other sort of interventions that the ACLU has done. Happy to answer questions about the ACLU's decision-making on a host of issues, and my agreement or disagreement with that. But really it's sort of like, well, what do you do when you make a choice about you make a series of choices about how you want to engage in the work that you want to disrupt, and you know that there are always compromise choices, and constrained choices, and potentially harmful ones. So that's sort of what I'm interested in talking about, and I know Chase has some questions to get us started. I've already forgotten them.
That's why I have this trusty note here for you and I. As you were talking, I wrote down 3 things: visibility, praise, and movement decisions, and the relationship between those things, the ever-shifting constellation that I think we all encounter in this movement of hyper-visibility around trans issues. And it strikes me that we're also talking about exemplary cases. We talk about what happens when Chelsea Manning becomes the singular subject, what happens when Gavin Grimm becomes the singular subject. I think about legacies, now attached to the bodies of people like Matthew Shepard or Brandon Tina or Rosa Parks. And so I wonder if you might be able to speak to where cases like Chelsea's or like Gavin's fit into your understandings of the larger movement.
Yeah, I mean, it's obviously, it's complicated because Chelsea, so most of those people that you named are white, and Chelsea and Gavin, of course, are. And they're examples of individual cases that did come up in the context of, they were having a specific challenge, a problem. They were facing very particular forms of violence, and came to the ACLU for assistance. And then, for a number of reasons, their cases became very high profile. There's other examples of individuals who don't fit that pattern initially, who are literally, we go out and get them. Like, so we decide that there's a legal problem that we want to attack, and we go pick our plaintiff, and we have a set of criteria that we're looking for to fit a mold to tell a story. And that isn't necessarily wrong, it's just what happens. But it's not some organic, like, we're looking for people who are experiencing the most harms and then representing them. It's we're going out and picking someone who is most palatable and telling their story in a way that seems legible. I think that it is such a product of the law and the legal, the law, lawyers, and the legal system having so much power over our movements that we sort of have individualized narratives in this way, because this is how the law operates. It operates to individualize problems, to absolve systems, to make to make it seem as though an individual bad actor or some small number of individual bad actors have harmed one person, and that we can understand both the problem and a solution through one person's trajectory through life, usually someone who already has a lot of access in some way or another. And so I think it's really dangerous to look to Chelsea's story or look to Gavin's story as sort of the way in which we're going to understand how to sort of fight for justice for trans people. At the same time, I've worked really hard at the ACLU and other places to say, well, we have to tell the stories of trans people if we're going to do trans advocacy, because the flip side of all of this is that for many years we just pretended trans people didn't exist at all because we were so afraid of having trans bodies exist in public at all and part of our stories, and so we wanted there to be individuals to attach meaning to the violence that we knew people were experiencing. But it's so easy to see how some stories get elevated and become sort of symbolic of both the problem and the solution, which is, really nice white kid from Virginia, very articulate, has a mean school. And this is not how I think about Gavin. I find him to be a hero, but if you're looking at sort of the cultural production of this story, it's, poor kid from Virginia, mean school, like, file a lawsuit, win. Justice, and that of course is how civil rights movement narratives have been told because of the primacy of law in them. It's like, school desegregation, Brown versus Board of Education, yay, like no more segregated schools, but like obviously lots of segregated schools, no matter what happens in Gavin's case, like lots of violent norms being imposed on sort of non-conforming bodies. Lots of fear of of black bodies in the United States. Lots of judges telling black men they should never have been born. And so if we're just looking at sort of individuals and their stories and their heroic triumph over the bad actor, then our solution is always going to be more laws, more rights, more fitting into the structures that we have instead of, destabilization of the system as a whole, taking away the ability for the law to constrain people's ability to organize, taking away the ability of the law to be a constant force in locking people away. And so, it's something that I rely on very deeply to have people tell their stories and be their own voices and narrators of their experience. But the problem is the constant repetition of that story, and then the manufacturing of that story in the form of especially a civil legal complaint, then has this really broad-reaching set of consequences. And I don't know that I would always say that I wouldn't make the choices that I've made. I just think that we have to be real about those consequences.
And it strikes me there's incredible similarities to the way in which people discuss Laverne Cox on the cover of Time magazine, and this production of trans visibility as a tipping point toward what? I mean, I would argue you could tip all ways, right? But toward the understanding that with visibility becomes greater access to fill in the blank.
Yeah.
And most people would also say, and it matters. At the same time, it does matter that Laverne Cox becomes a speaking subject, a positioned person in public around these issues. And I'm curious how much this production of transness in culture via magazines and movies and television shows impacts the work you do. Do you feel like you are in dialogue with broader cultural narratives for or against in any ways?
Yeah, I mean, I think it's exactly how you describe it, in that it matters, and it is sort of, I think all of those types of cultural production that have both the benefits and the limitations that you name, and that are, sort of incomplete narratives in themselves, like what does it mean that, access to what, and for who, is really sort of exactly how it's playing out, I think, particularly in the mainstream civil rights movement, which is, and this is how it has progressed over and over again, which is why I sort of hoped for better from like, it's like when you're doing it after like 5 failed examples of something, like why are we not doing it differently? But the visibility does change sort of the nature of the legal advocacy, and the legal advocacy changes the nature of the visibility, and they're all connected. I think what I see is that there's more of a willingness, in the post-Liver and Cox Janet Mock moment to center trans individuals as speaking subjects, as narrators of their own experience. And then it means when you take on a case on behalf of a trans individual, instead of having surrogates speak for them, like we're allowed to speak for ourselves. But it doesn't change the kinds of cases that we're taking. We're just trying to find the examples of legal advocacy narratives that mirror Liver and Cox on the cover of Time magazine. And so I think that's a lot of what you see is sort of like what becomes palatable in the among broader cultural norms drives what types of legal cases that you see. And it probably goes both ways, and there's a lot that happens where Laverne Cox, for example, was involved with a campaign with the Sylvia Rivera Law Project on behalf of their prisoner advisory committee and individuals who were incarcerated in the New York State prison system, sort of at the very beginning of her sort of rise in more popular cultural context, and then she started getting attacked because of the crimes of conviction of some of the individuals that were part of SRLP's prisoner advisory committee and sort of who she was speaking out on behalf of. And so then she decides she can't be associated with that, which is totally her prerogative. She's trying to survive, and her well-being is on the line in many ways, in ways that other people who are staff at SRLP are not. Like I was a staff member at the Sylvia Rivera Law Project, and I had a lot less precarious access to resources than Laverne Cox did at that time. So I wasn't going to stand in judgment of her, but the reality was that her ability to maintain her platform in her mind meant not being associated with types of narratives of transness, which is exactly what we do in our legal work, which is to say, it's not like we don't do that work, but we don't talk about it. We don't do the communications around it. We don't make videos about our clients on death row in the same way that we make videos about Gavin Grimm. And so what does that mean for the story of transness that we're limiting ourselves to? And is it just going to look exactly like the progression of the gay rights movement, of the women's rights movement, of the civil rights movement? It's just this constant repetition of norms of exclusion and fear of association with people who disrupt the respectability or the sort of coherence or legibility of the idea of the trans subject that you're trying to build, and if you push back in conversations and legal organizations, for example, then the answer is always, well, we can't win, if we don't have X. And that's true if you're limiting your notion of winning to like winning a legal case. You can't win. You can't, you won't win in like the Supreme Court certain cases. We know that. We know what cases are winnable at the Supreme Court and which are not. Especially in the types of work that we do, especially like in the LGBT advocacy context. And so maybe we make our calls, we make our compromises, we go along, we don't quit our jobs, and we figure out what we can do within the constraints of where we're operating. And to me, I still think like Gavin changed the game in a lot of ways. He was an incredibly amazing spokesperson who I have so much respect for, and we didn't win his, and we lost it, and we did nothing happened in his case. There's no decisions in Gavin's case. He never went to the bathroom in his school. So it's sort of like we didn't win in any sort of like real way that you would see consider a measurable win in piece of litigation. But Gavin had a lot of wins, and his life changed dramatically, and I think he made it possible for others too. But which others, and how much? And I think those are the types of questions we have to ask ourselves before we start declaring like major victories in the transformation over trans lives and bodies. And I sort of traverse a lot of different spaces and watch myself sort of overclaim victory when I think it's important to temper that.
Let's open it up. Thank you. Questions for Chase?
So, this is outside of your purview, but because it's such a in the news thing, what are your reactions to David Boies being Harvey Weinstein's lawyer and that whole thing this week that Ronan Farrow brought?
I saw that, and I am not, and that was like so recent, and I have been so caught up in this that I haven't been, I mean, but again, here's the thing, nothing surprised. So,
David Boies was, along with Ted Olson, one of the lawyers that helped win marriage equality, and now we find out that he was a part of the Harvey Weinstein cover-up of all of his misdeeds because of Ronan Farrow.
Yeah, so I mean, I guess I'm like, hearing that David Boies and Ted Olson is involved in like a nefarious plot to maintain the supremacy of people with a lot of power, to me is just like the sky is blue. I mean, I think it's like, yeah, everyone's like, oh, these law firms it turns out all these law firms are doing all these horrible things, and I'm like, wow, no way. I can't imagine that the corporate legal world would be involved in I mean, their job is usually is somehow connected to merging power and maintaining wealth for powerful people, which is precisely what this all is about. And so, so I think it is sort of relevant insofar as it's like, can you ever be surprised to learn that lawyers are people who are part of the entrenched systems that I and others are a part of are acting to maintain those systems? It's like, no, that is what they do, and then we act surprised. It's like the judge being like, I don't know how we got here with these problems, and I'm like, really? You do know how. You're sitting there, you're a federal judge, you know exactly how. We set up a constitution to maintain slavery and have tried to maintain the consequences that flow from that since that time, and one of the ways that we do that is by sending people to prison, and you know that, and so I think it's just one of the, it's like, of course that's what he was doing, and of course that, it's like you find out that Wilmer Harrell and these other huge law firms are behind all these things, and I can't say that it's surprising in the least. And certainly someone's association with marriage equality, especially Olson and Boies, doesn't immunize them. And this is where that federal judge also had some sort of random role in relation to Robbie Kaplan and Doma, that obviously I didn't care enough to remember, but enough to remember that these are democratically appointed judges. These are people who consider themselves liberals. I mean, not Boies, but who are acting to maintain this system just as much as the people who we now associate with Trump. And so yes, I would say that I am not surprised. Even though I know none of the details, if you just distill it down to lawyer does bad thing to maintain power.
It was a robust answer to something you know nothing about.
Well, I'm pretty much always willing to talk, even when I know nothing about one of the many.
It's in the New Yorker, if anyone wants to read it.
Kristen.
Yeah, so, as a sociologist, I am dubious of the law and its capabilities. But I'm also somebody who is very suspicious of progress narratives in terms of a civil rights thing or the utopias that we're fighting towards. But I have to say that after Trump got elected, I suddenly thought I should have gone to law school, because it started to feel like the law was becoming one of the only tools that was particularly wrestling the Muslim ban, or that was able to sort of throw a wrench into what seemed like all of a sudden, even for me, a backsliding of things that I had come to take for granted. So I'm wondering if that changed your view at all. of the law.
No, and in fact, I find it like to be one of the most disturbing consequences of this moment is this idea that the law, like the lawyers as heroes, like the ACLU as heroes, the judiciary as the stalwart against fascism, because. But I see why it's happening. I mean, I think things feel really out of control, and you can sort of go into court, and a judge can say, stop doing this thing that you're trying to do, and that is sort of satisfying, but it's just another one of those progress narratives on a smaller scale, repeated over time 1,000 times because of what's going on. But I think that what hopefully is becoming more clear is that all of these, I mean, yes, you can go to, we'll go to court, and these are, I think it's a tool still, and an important one. I'm not saying that, like, I mean, it would make no sense for me to have the job that I have if I didn't, on some level, believe this is a useful tool. But, you know, we're not, the judiciary is still the judiciary. The law is still the law. We're still, if the best we can do is what this gives us, then we've lost already. I think, especially now, what we can see is how the series of injunctions, for example, that we've gotten in the Muslim ban cases, or that we inevitably will get in the trans-military cases, or in the Jane Doe case, or, you know, all of the things that we're winning, you know, the system is just adapting to create new obstacles. It's always going, you know, it's like there's no end in sight, really, to sort of the destabilization of, or even, it's not it's just sort of the operation of this system. It's like there's like what, we're on like Muslim ban like 4.0, and everything gets mooted out, and that the administration is very deliberately trying to both confuse us, exhaust us, moot out our cases. I don't even know that they care about any of these. Of course, you know, it's just more of a way to produce fear, confusion, and absorb resources, and these are all resource-intensive things. And so what we're just doing is sucking all this money and attention into these fights, and leaving behind so many people, and then getting tired, and then, you know, fighting the sanctuary city orders, and then trying to figure out, you know, and then Congress is operating over here, and you're trying to sort of stop them, and really, I still think that the law and litigation is just really, I'm worried about the narrative that's our path forward. I still think it's a tool. It's good to, you know, it's like, all right, you know, you stop that, you let some people in, but if it ends there and it's not, because it's just going to keep changing, and the organizing and the redistribution of resources and the getting people into different spaces and moving money still seems to me to be like the urgency, and the law is just perhaps a place where we can sort of hold back some sites of violence long enough that people can do more together. That's sort of what I think of the role is, like, you know, sort of pushing back so that people have a little more space to be creative and survive, but not to make a new space that we want people to live under. Whereas I worry that under this Trump narrative, and this, like, the new hagiography of George W. Bush, is that all of a sudden we're like, oh my God, like the times were so great when we just had the law, just people believed in the rule of law, and I was like, what is the rule of law that you believe in? You know, it's like, and so. Like Sessions believes in the rule of law too. It's just he talks about it differently, but it's a lot of the same. And so I still think you did the right thing.
Okay.
I mean, I had a friend who was like, who did federal policy work, and she was a lawyer, and after the election, she's like, God, you know, maybe I should shift to environmental work, because I feel like it's the only place where it seems like reasonable to try to make compromises with this administration. You know, it's just like, I think we all just sort of took a moment, maybe, and thought, well, are we doing the right thing? And probably not, but like, we're doing what we know how to do, and so that's always better than, you know, making ourselves miserable.
Thank you. I very much appreciate your comments. And I mean, I'm someone who's always been very suspicious of the way in which we citizens, you know, tend to imagine political change as originating in legal change, and don't see legal change as essentially an effect, in a way, of changes that came on the ground before it. So, whatever, the 1964 Civil Rights Act, the 19th Amendment. I mean, all this idea that all of these momentous changes in legal history actually just kind of, sprung into being, and from that we got genuine political change. And so what I'm saying is that there seems to be a real confusion just generally in the way we tell ourselves the story of political freedom in this country, where we think that all change originates in law, whereas it actually originates in social movements and always has. And yet at the same time, not yet, and added to that is then this sense, specifically now speaking about feminism, where if it doesn't appear like there's another law that has to be changed, then the movement's over. I mean, what is there really left to claim? So the kind of exhaustion of political energies and the exhaustion of political imaginaries at the point where it seems as if there just isn't any other law that we absolutely have to change, seems to me just this huge problem for political the kind of political transformation that you're clearly interested in, and I think we probably all are as well. And I, often as someone working within feminism, I don't know how to sort of really shake that up, because on the one hand, there are all these people on the ground who really are doing political work, and it's not just focused on changing the laws. But yet in the kind of general political imaginary of what feminism is, or even LGBTQ rights now, it's like, well, there might be a few laws we still need to tweak or whatever, but basically then it would be over. And I know it's never over, but I guess it's, I keep thinking, is it that, what can we actually concretely do? One, to remind people of how the legal changes came about in the first place, that they originated in political movements and not in law. And secondly, remind ourselves that exactly what you were saying, that at a certain point, yes, law is enabling, but it also can become an obstacle to the forms of freedom that we're interested in.
I think what happens a lot is there's a very deliberate way that the system uses the law to neutralize movements and to constrain what we think is possible. And sort of equality frameworks have done that to us, I think, and sort of limiting our goals to visions of equality and access to equal treatment under the law. And so I think what that looks like is both the production of the narrative that you're talking about, where it's like, people just went in and the laws changed and then all of a sudden there was progress instead of all these people working for all this time. And actually then what happens is the law comes in and then constrains what actually people were working towards. It's like you can have a movement that's demanding like survival and redistribution and food and healthcare, and then all of a sudden it becomes about the Civil Rights Act. And what the Civil Rights Act does is it doesn't say you get anything. It says you get to be free from discrimination. But in order to be free from discrimination, you have to prove that someone is intentionally discriminating against you. And so all of your energy now is caught up in trying to establish like motivation of individuals. And the movements then get caught up in the endless fight to pass laws in Congress and state legislatures, and that drains resources from the more robust demands that were being made. So the law operates to sort of neutralize that and then act as though it was always there as sort of the thing that made progress happen. I think and I think I see this a lot in a multi-issue organization where people are always like, oh, we're so jealous of the LGBT work because you guys still like don't have formal equality. This is a very perverse conversation because it's like, because it's like, oh, you have fundable work. Like you could try to get laws instead of just trying to like save people's lives and create justice. It's like, oh yes, you can fight for marriage equality and you can fight for non-discrimination. We already have those things and everything still sucks, but there's nothing we can do about it, And of course that's not true and that's not how anyone thinks, but that's how rich and powerful people think, and so that's how it gets funded. And so I think, to me, the work is so much about exposing the narratives like that neutralized our movements and sort of the ways in which, the law and driving people into legal reform seems to be a very deliberate operation of our system that is part of how our Constitution was set up, it's part of sort of how our democracy works. And then it's part of the sort of bargains that happen where, I think the powerful decide, okay, we'll give you a carrot and you're going to fight really hard to maintain it. And what we might imagine our work consists of more now is to say, all right, well, what has the law not, what has the equality framework not done? It's not done anything, or it's not provided us most things, and so what are the demands that we want to make, and how can we work towards getting those? And I think it's scary because what it means is convincing people to give up their power and fundamentally changing the system. Our system has to be more redistributive in order for any of this to be meaningful. It has to not rely on criminalization, which is something that people are incapable of imagining. And in my view, it essentially can't be capitalism, and that's something that is not going to sell for a lot of people. But even without all of those demands, I think, I see the work as, it's not about making claims for inclusion in non-discrimination laws, which is what the LGBT movement seems to want to go towards, but instead, building power within the community to say, we have a problem of the way labor is treated in this country writ large, and not an employment non-discrimination law where you have to prove intentional discrimination isn't going to help people. You're going to be discriminated against because you have a criminal conviction. You're going to be discriminated against because they think you're ugly. You're going to, it's like this is how it works. And so why not we instead say, you know what, the trans community will never be free and have access to, to control their labor if we don't change labor fundamentally. We're never going to have access to trans healthcare if we don't change healthcare fundamentally. Instead of saying, well, let's take our healthcare system as a given and just add in this. This is how it works. These are how our reform movements work. They just add things on and don't look to change the structure itself. And so I think we get caught in sort of being placated by small wins, which is like how most of these movements work once the law takes hold of them, and our demands become more and more compromised because we lose sight of sort of what it would have meant at the outset to sort of maintain our robust demand that we would have inevitably lost by someone's metric, and then it would have stopped being funded, and then what happens? But now look where we are. It seems like people are maybe willing to ask some different questions and build different alliances, and recognize that maybe equal treatment under the law when everyone's getting shitty treatment isn't actually what we should have been fighting for. Yeah, I think there's a lot of people who write about this in very helpful ways, and I think, but it is true that we're all caught up in this system, and then you just see people falling back into, well, let's pass this law, and let's pass this new criminal law, or let's make it harder for people to be sexually harassers by punishing them more. And then you're just like, okay, well, we obviously are just going to have the same conversation and make no change forever.
Well, following up on that, I'm really struck by both the way you described the law functioning through these individualizing stories, but there you're talking about the ACLU clients as the individuals, and then this question of motivation. So the law is built on determining the motivation or intention of the bad actor. And I guess I'm curious, do you think there's a way to use the law or shift the law to move out of the question of was harm intended, and to ask the question, was harm done? You brought up this thread of these sexual harassment charges and the discussion that's happening, and for so many people the solution is, oh, people were fired because they were clearly bad people. And how do we move past, like, even if it wasn't intended, even if there are some people who unintentionally create harm, the harm needs to be addressed. Is there a way for the law to be used to step outside of motivation and individualization, or is it trapped in that?
Well, I mean, I think it can be used. I just worry about our over reliance on the law, and it's just sort of like we quickly go to the law as the answer. We quickly go to either so to some sort of, usually it's through consolidation of resources in the criminal system in some way or another, and so then it's like, well, if that's our only impulse, then no. I don't think the law should be even a part of the equation, because I worry about what happens once you start funneling resources in that direction. Last term, the Supreme Court, the Fair Housing Act, which is one of the civil rights laws that prohibits discrimination based on, among other things, race, and it retains something that is lost in the law very much most of the time, which is disparate impact.
Right.
And so the Supreme Court did, in a sort of shocking moment, retain disparate impact as sort of part of the Fair Housing Act analysis. And so you could show race-based discrimination in housing based not just on intent, but on impact, and disparate impact alone, which is pretty much lost in sort of most of the constitutional analysis around discrimination. But disparate, that's just a very, very, that's just, to me, is just like not enough, because, and I've been, lots of people have pointed out that like housing discrimination and sort of the ways in which people are displaced through housing markets doesn't operate exclusively through, systems that you can identify and hold accountable through litigation. Often, I mean, it's zoning, it's so many different things, and so if you're not going to attack the regulatory state in the way in which regulations are moving people around for the purposes of making them marginally housed, taking them out of public transportation, making them outside of different sites of education. And the law is not good at addressing this. Certainly discrimination law is not. I don't know that that type of legal intervention can. I don't think civil rights is the area. I think because rights are individual concepts. Rights are really about the state telling you, what, sort of how to rectify an injury. Whereas if we look more to sort of systemic change, I think the law could still be useful, but it would have to come through sort of a different type of analysis, I think, where you talk about the nature of regulation, and the regulation, executive regulation, I think, is so much of what perpetuates our legal system, and we don't, and you can sue over it. You can be like, oh, this was promulgated in an arbitrary and capricious way, and bring lawsuits that nobody is interested in because they're so, procedural, so they're not as catchy. But I think if you become and people who do regulatory work in a really radical way and try to change the way that agencies promulgate regulations and the ways in which our lives and our bodies and our time and our space is controlled through the law, which is not through congressional enactments or civil rights, I think we may have more potential, but it's just a lot less, it's just so much less transparent and so difficult to understand and make visible for people and to get people engaged. But I think there's more potential there than in, say, trying to sort of pass more laws. I think we should pass fewer laws, and sort of find more laws unconstitutional and strike them down, and then build out more space for creativity and the types of demands that we would want to make on our government, if that's who we think our demands should be made to. So I worry about the impulse to pass more laws, because then usually the horrible things get tacked onto them.
When you decided to study law and become an attorney, did you have a different mindset, or were you always thinking that you were going to do pragmatic work against a background of massive injustice?
Did I always think the job I was pursuing was pointless? Yes. That's a good question. Yeah, no, I mean, I think my sort of the nature of my concerns have changed a little bit, and when I went into law, it felt like a very much not what I want, not what I never expected to do, and was concerned about the impact of the work, and thought, and truthfully thought, well, if I think what's changed for me is I thought I could do it in some way that would make it pure. Like I could do the radical lawyering, and that would be the answer. And I think I quickly learned that like the reproduction of the problems and just nonprofit institutions are all have their problem. You know, it's all the same and just a different. It's a different degree, or it manifests differently. So I thought I could find a way to do it that would be pure, that would be all outside the system, which is sort of absurd to even say out loud, because it's like, well, how do you be a lawyer outside the legal system? And I do think some organizations, including Sylvia Rivera Law Project, where I first worked, sort of claim to do that, and of course they don't. And I was sort of disillusioned with the idea that you could do it, you could be pure if you combined law with organizing enough, or if you talked about it as in a radical way enough. And then I was quickly disillusioned by those ideas, and realized that the only way that I could do it was just to be honest about the limitations, but that I still thought, and still do believe, despite all of these criticisms, that in almost all of the work that I do, there's some good things that come out of it, and that there's some worthy conversations to be had. I just don't think there's any, so-called pure way to do it or cost-free way to do it. There's just decisions that you make, partnerships that you build, consequences that you identify and then subsequently address. So I guess I went into it thinking, okay, I understand this is a problematic system, but I'm going to do it in a non-problematic way. And that's where I don't think that's possible anymore. And I think I had many frustrations with those super sort of claim to be radical organizations, because I was like, all right, guys, come on. Like, we're also just as problematic as the ACLU, we're just different. Differently so, or a little better, or better in some ways and sort of in denial in others. And that's where I think I've just sort of watched, all sorts of things where I thought, oh, the answer is here, we're going to be perfect, or we're going to do less harm, or we're going to do no harm, and then just realizing that actually maybe what we can do is just be really honest with ourselves.
But what I really appreciate everything you're saying and how you're, really describing the legal system. And what comes to mind is I'm really curious to hear how you and your cohort at the ACLU think about the weaponization, in fact, of the law, right? And here I'm thinking, of course, of, the way that, the freedom to discriminate, right, for religious purposes, or personhood, right, in order to discriminate against. So basically along religious lines. So I'm just curious how you guys, how you in particular, and how you all at the ACLU or in people who share your mindset think about that, because for me this is the extension of exactly what you're saying. That it's like let's limit the laws and actually change systems. Whereas I see also, especially in the Trump era, the weaponization of law. And that's my term, but in order to forward things that are actually discriminatory under the umbrella of freedom, right, or equality. So how do you understand that as a political ethos, or how do you fight against that as a political ethos, or how do you guys at the ACLU think about that domain, or do you think about it in those terms?
It's sort of why you can never be a purist, because, of any sort of legal principle, because there's always a competing principle that one could claim with equal force. It's like, I have a freedom, I should be free from discrimination, and someone else claims, well, I should be, free to practice my religion, and I should be, I have free speech, and I should have the freedom. It's like there's no sort of way to reconcile these things without imposing a value judgment on which one is more important or more just and correct. And I think the challenge at the ACLU or at institution in law in general is people try to say that there's some principled way to sort of draw these lines, like doctrinally principled way. That's like, oh, well, the line on speech is here, and this is how you can sort of reconcile these tensions. And I think we're ultimately all of the time making value judgments, political judgments, decisions that aren't like scientific in nature, and so as much as it feels like it's sort of emboldened right now, I think this has always been true. It's sort of like religion to discriminate is sort of one of the oldest, characteristics of our country, and freedom of religion and freedom of speech were very much principles that were designed to maintain and elevate, slaveholders and people, white property owners, and so it's actually, so the conversation has always been there, and the tensions have always been there, and I think our responsibility is to acknowledge that we're, making, you're never going to be like for a principle. I don't know, maybe you are, like, but within the confines of like doctrinal constitutional principles, you're going to come out different ways depending on who you care about and what you care about, instead of being like, well, if I'm always for free speech. And it's just like, that's not how I operate. That is how some people operate, but it's all historically contingent, and what we even mean by these concepts is very much constrained by why they were developed in the first place. And so when dealing with the ways in which individuals are now claiming a sort of religious or conscience or moral-based right to be exempt from generally applicable laws, or to be able to discriminate, or not follow the contraceptive rule, or not, or to discriminate in public accommodations. I think as lawyers we have to find a rule that the courts can follow to say, well, no, that the laws of general applicability don't allow you to act in a discriminatory manner when your religious beliefs aren't being burdened, and there's a doctrinal answer, but it doesn't necessarily change the behaviors or the sets of norms, or even just the idea that our rights are always going to be in tension. And so we have to have more than just that. We have to believe in more than just rights, and we have to stake out hard, positions that. I have to. People definitely don't agree with me at my work, but I feel the need to, and to sort of say, well, there's a limit to what I believe in. I think the Constitution is wrong. I don't believe in our Constitution in every way, or in many ways. So that's not like the norm position of the ACLU, I would say. But I think we give out constitutions everywhere. And for sure, there's things in the Constitution I like and rely on. But structurally, structurally speaking, we should be very clear about. We set up our government for very particular purposes, and the legacies of that are playing out in our legal system in the way we advocate for legal rights. And I still do it, and so I don't know, it's like I still do it. I still participate in these cases, and I still go do legislative advocacy and make constitutional arguments, and then talk about it in this way. And I guess I just always have been a very conflicted person in every way about how to live in the world, and so that's maybe why I'm trans. I don't know, but it's like or maybe that's because I'm trans. I am this way. Who knows?
Next up on the Chase Strangio. Trans, question mark?
Is it a choice? I don't know. People really don't like having that conversation. I don't know. But all this to say, there's no simple answers, and we do have the conversations all the time, and I think when I get concerned is when we act like there are simple solutions, or that somehow in the Constitution we can locate the answer, when it's like, no, we just have to stake out a position, and maybe sometimes we're like, the law is wrong, instead of if the law is always right, what can we do within that?
Is there any hands, sorry Linda, one moment. Are there any hands lingering behind this pole that I can't see?
I don't see no people.
There's no
Just trying to read the room.
So I actually really admire your pragmatism, because I think that one of the real dangers in politics now is to think in purist terms, one form or another. So, pragmatism is good, that there's certain things you can achieve, but be realistic about what you're achieving, the harms you're creating, etc. So I admire that. I think that there's a difference between, let's say don't take this the wrong way, but like, you know, sort of justifying to yourself, like why, you know, justifying to yourself why you chose your career, what you can achieve, the things you can, and that, you know, and the larger problem, which I mean, the problem isn't that there are people like you who pursue law and use law against law to change law, whatever. The problem to me still comes back to this fundamental confusion of political change with legal change, or the exhaustion, the reduction really of the very idea of political change and what it involves to legal change. And that's something that you know, that's where I keep hitting my head up against the wall, because it's just so hard to even imagine like political movements without thinking about that they're aiming at some kind of change in the law. Whereas they're actually building all of these relationships and generating all these skills, and all this stuff is going on that has absolutely nothing to do with changing the law, but has to do with changing the way we live with other people. And this isn't going to come out as a question, so I'll just kind of leave it at that. I mean, I don't know. It's just the way in which a kind of legal grammar so dominates our political imaginaries. That's what I see as the biggest problem. It's not that there are people actually out there like yourself, you know, sort of trying to get certain laws changed, or other laws not changed, or whatever, but rather just the way it has seeped into political movements, such that they can't imagine themselves in terms other than legal ones.
Like, let's say that the night of the Muslim ban, like the first days where everyone's mobilizing at the airport and organizing, and, you know, because there were lots of different lawyers operating in those moments, giving people services, helping people get out. You know, there's lots of different things happening. But what if the ACLU just never went to court to try to strike it down? What if that moment didn't eclipse the rest of them? You know, I do think there's individual actors and decisions that actually do impact this narrative that you're concerned about. And not to say it's me and it's my fault and I'm so self-important, but like, what if we didn't do that? Like, what if we just didn't go to court sometimes and instead let these things sort of sit and grow? And maybe it's all about getting someone out of that airport, or getting someone food, or getting someone here, or giving someone cash. And we just spent more time slowing down and taking that and building those things instead of rushing to court and both eclipsing the narrative of that story and also extracting resources towards that fight.